I'm Jay Sekulow, S-E-K-U-L-O-W, Chief Counsel of the American Center for Law and Justice. I represent in this case 70 members of the House and Senate, as well as 260,000 citizens from all 50 states. One thing I think became very clear today by the Supreme Court, and I think probably unanimously, and that is the Pledge of Allegiance is a reflection of the religious heritage of America and does not constitute a violation of the Establishment Clause. It's very clear that the court has recognized that, at least through the oral argument, that in fact the Pledge of Allegiance reference to God reflects an historical truth that our founding fathers believed that rights, liberty, and freedom derive from God to mankind rather than simply from government. That's what our founders believed. That's what the pledge incorporates, and clearly that's where the direction of the Supreme Court seemed to be going today. And I thought Dr. Newdow did very well. He was a good oral advocate for his position. I think that the law and Justice Kennedy's comments, I think probably most significantly here, the author of Lee versus Weissman, distinguishing between prayer and this patriotic expression, though, is very significant. So while I think Dr. Newdow did a fine job arguing the case, I thought the lawyers representing the school board and, of course, the Solicitor General of the United States did a very, very good job as well. The advocacy was very good on both sides. I think it was pretty clear that this court recognizes the historical significance of the Pledge of Allegiance and its constitutionality.
Jay,
yes.
There was questioning from the justices about whether, on the standing question, whether if they allow him to argue this case, that undermines the court's rulings on the rights of the other parent. Do you think the court will focus on standing?
Well, the first 10 minutes of the oral argument focused on standing, but I think at the end of the day, the court is probably going to reach the merits of the case, but I think it was very clear that the court has recognized here that the Pledge of Allegiance is, again, a reflection of a historical fact that our founding fathers, the founding generation, believed rights and liberties derived from God to mankind. It wasn't just the grace of government. So the standing issue may be close. I think it's probably close. There's some serious standing questions. But if they reach the merits, and I think they will, I think the court is going to overwhelmingly affirm the constitutionality of the pledge.
Did the justices seem skeptical that he had suffered any harm?
Well, I don't think it was a question of harm. Isn't really the standard. The standard is it a redressable injury? And I think the fact of the matter is that the standing question was a close question. There was a lot of questions in the initial portion of the argument, but it seems like that's too close to call. I wouldn't give a prediction on that one at this point. Anything else? Thank you. Yeah, Jay Sekulow, S-E-K-U-L-O-W. I'm Chief Counsel of the American Center for Law and Justice. Thank you.